Yes, my dear students, a very good morning to all of you. And I hope all of you are rocking, doing fantastic. Yes? Huh. Yes, I'm also doing good, sir. Thank you so much. I'm glad that you asked, you bothered, you are concerned. So, why are we here today? Obviously, to continue with the basic concepts which we have started. And what are those basic concepts? Only chapter number 1, preliminary. No, sir. Apart from that, a few more things as you have mentioned. And what are those few more things which I have mentioned? Ah, chapter 1 anyways I have mentioned, sir. Abhi bola na, chapter 1 is there. Apart from that, I am asking. Again, you say definition means what should I say? Chapter 1 means section 1, section 2. Anyways, I have covered. Now you have to talk about other things. Please sit straight, madam. Features, limitations, residential status, section number 455, dormant companies, 464, illegal association, isn't it? Like that, there are few other things which we have to cover, isn't it? Yes, sir. So let us now try to recall what we have discussed yesterday. Definition of company given under section 2, clause 20. And it says what? Company means a company which is registered under this act or any of the previous Companies Act. So what does it mean? It simply means that registration is mandatory, whether under Companies Act 2013 or any other previous Companies Act. That is it. So that is where we understood that it is not giving complete meaning of the term company. Complete meaning of the term company. So thereby we said we'll have to move on to other sections, other acts like SEBI Act, SCRA, Depositories Act, isn't it? Remember or not? Now why these laws only? Why SEBI Act, SCRA, Depositories? Why I have mentioned these three first? Because Companies Act asks us to go there. There is a clause in section 2, that is 2 clause 95, which says 2 clause 95 is the last clause in section 2. So it says that if you don't find anything in company law, then you may go to Depositories Act, SEBI Act and Securities Contract Regulation Act. The Companies Act is saying that you have to go to these three laws. That is why we go to, come on, these three. Okay. And we don't find, still we don't find something, then we may go to General Clauses Act. Why? It is my favorite. That's why we have to go to General Clauses Act. No, then why? That is an interpretation related law. As I have told you, that is an interpretation related law. So obviously when we are not able to get something, then we go to the interpretation law. And that's where after those three laws which Companies Act asked us to go, we went. And since we didn't find the answer, that's why we came to General Clauses Act. There also we don't find. Then we go to other laws. Other laws meaning other than Companies Act, other than these three acts, other than General Clauses Act. Any act. And why do we prefer section 2 first? Because normally we know definitions are given in section 2. Normally. If we don't find, then we go to other sections. And then further, if we don't find in laws, then we go to case laws. Which case laws? Only the judicial body decisions? No, even quasi-judicial body. Still don't find, then we take the help of dictionary, experts, right? Features, functions and all, and define it on our own. Correct? So, we went to few case laws and understood. Justice Marshall defines it as what? An artificial person with no physical existence. It is invisible, intangible, exists only in contemplation of law. But that's not helping us fully, and that's where we have to move on. And then we saw Justice James. James defining what? An artificial person? No, an association of person united for a common object. And then Professor Haney. Professor Haney says what? Professor Haney says it's an artificial person. No, again, it's an association of persons created by law, having separate legal entity and perpetual succession. Am I right? So these three definitions giving something, no doubt about that. It's an association of persons, it is existing in contemplation of law, it is united for a common object, right, having separate legal entity. But don't you think if all this is combined, probably we'll get a good definition, right? And something more is added, then probably we can say it's a comprehensive definition. Yes. So that's where we said we'll take the help of what? We'll take the help of what? Features, right? So that's where we moved on, and we started with what? Features. And if you remember, these are the features. These are the features of company. What are the features of the company? Come on, tell me, guys. Voluntary association of persons. Correct? Voluntary association of persons. So only voluntary association of persons is enough? No, sir. They have to get registered. Simply some association of person comes, we cannot call them as company under company law. It has to get registered under company law. That is where what? Registration. Registration done. Then what? Obviously it becomes a corporate personality, a legal personality. It gets separate legal entity of its own. Right? And that is where we say that liability of members becomes limited. And that liability is on the basis of share capital. So next feature, share capital. And these shares, once you purchase, do you think you have to hold it for lifetime? No. That's where transferability. The shares are transferable, isn't it? Right? So that means member may come, member may go, but the company goes on forever, forever, forever. That means perpetual succession. Right? Perpetual succession. And how is it possible to have perpetual succession? Because ownership and management is separate. So separation between ownership and management. Is this exhaustive list? You decide one. Is it an exhaustive list? The answer is no. Why? I've written etc. already. That means there can be more features added. Is it only company form? You can write these features? No, we can write more. But we've written the most common ones, the most important ones. Correct? Because we are in our initial stages as well. Okay, guys? You able to follow? So before giving answer, always please think. Don't immediately rush to answer. I'm not going to give you any prize if you give the answer first. Isn't it? So think what sir is asking. Just ponder over the question which has been asked and then come up with the answer. That will be better. Okay? Right, sir. So now as we said, we have to discuss these features. We have to discuss these features or not? Yes, sir. So first let us talk about voluntary association of persons. I hope you have put today's date. Right? If you have not, please put today's date. So voluntary. Come on, you have to tell me. You're just staring at me as if you're hearing this term for the first time. Voluntary. That means no compulsion. You cannot apply undue influence. You cannot apply coercion to make someone join the association or to make someone associate with you. Isn't it? So that we understand. Association. So this means there shall be minimum 2 persons as far as private company is concerned and minimum 7 persons as far as public company is concerned. However, there is no association required if one wants to incorporate a one person company. In one person company, how many members are there? Only one. Only one. So there is no association as such, but still that's a company. Correct? That's an exception. So general rule is what? General rule says that association should be there in a company. And we know, because we've read earlier, that private company shall have how many members minimum? 2. And public company minimum? 7. Okay, sir. So association word also we are able to follow. Then comes persons. Association of persons. So who are these persons? Munna, Munni, Ramu, Shamu, Bunty, Bubbly, Rocky, Rani. Only these natural persons? The answer is no. Sir, even legal persons. That means one company can become member of another company. We know this. So we need to understand persons means not simply natural persons. It can be even legal persons. So now we can say yes, we understood voluntary, we understood association, we understood persons. And they come together for a common object. They come together for a common purpose. Isn't it? If the purpose is not common, do you think they will be together? Come on. If the purpose is not common, if the objective is not common, do you think they will be together? Come on, take the example of our class. Why are we together? Objective is same. Is our objective different? Are you aiming to fail in CA Inter? That's why you have come here and you have associated? Answer was no. You've come here to not just pass. 60 plus is our target, I've told you. We want to score maximum marks. Isn't it? 60 plus is just the base. If possible 70, if possible 80. Why not? No, sir. No one has got in the history of ICA examination. See, there's always a first time. You never know. Isn't it? Till now, maybe no one has got it, but you may get it. Chandrayaan 3. So I don't have to tell you, correct or not. So please understand that these persons who have come together have a common object. Understood this much? Yes or no? Okay. So voluntary, then association, correct or not? Private company, 2. Public company, 7. But OPC is an exception where there is only one member. Don't look at the screen like this. Where I am reading, where I am, you have to concentrate there. Don't do that blunder or mistake of looking at the whole screen. जहां मैं बोल रहा हूं वहां देखो. Where am I talking about? Association. So look at association. Sir says private company, public company. Then OPC is an exception where there is no association. There is only single member. Okay. Next, persons. Natural persons, legal persons. Both are allowed. Both are or can be members of the company. Okay. Now, sir, object you said. Objective you said. They have come together for objective, some object. Is that objective always a profit motive? Yes, sir. No. There can be non-profit motive as well. You've read there is something called as Section 8 companies. That is non-profit organization. So there is a possibility that the objective may be even non-profit. It's not simply profit motive, isn't it? Yes, sir. Why are we calling those companies as Section 8 companies? Because the provision is contained in Section 8. So that's where we call it as Section 8 company. Earlier in 1956 Act, it was called as Section 25 company. Reason? The provisions of non-profit companies were mentioned in Section 25. But now it is in section number 8. So just in case you read some book and you find there they are saying Section 25 companies, that means that's an error, right? They have not revised that particular, what do you say, those particular words or that particular content. You need to figure out, you need to understand that they are talking about non-profit companies. Followed? Followed or not? Yes. Now, sir, what did you write on the right hand side? As I have told you, it's not just about understanding, it's about even application. Isn't it? It's about even application. So let's take a few questions and understand whether you have really understood this well or not. So that's where I have taken few questions. Very simple questions I have taken. Don't worry. So what is this? This is a partnership firm. They're holding hands together. So that's where this is a partnership firm. One partnership firm wants to associate with a natural person, Chotu, and start a company. Is it possible? Is it possible? A partnership firm wants to join hands with some natural person and start a company. Is it possible? Someone is saying yes, someone is saying no. You're not giving reasons. You have to give reason as well. So first let me ask you, those who are saying no, what is the reason? Partnership cannot be a partner. I'm not talking about partnership firm. I'm talking about a company here. Did I say that partnership firm with natural person wants to start a partnership firm? No, I said wants to start a company. Someone else also said no. Can you just raise your hand, those who said no? Okay, what's your reason, sir? So only knowing the answer is not enough. Even reasons are important. है ना? हाँ, Balaswamy. Reason you give me, sir. You're repeating the same sentence which your friends have mentioned. Who said? Who said? Balaswamy is saying, let me tell you, your answer is 100% correct. But if someone is asking you, where did you read this? Where is it written? Who said this? You have to answer that as well. So, my dear friend, please understand, as per Indian Partnership Act 1932, a partnership firm is not a legal person. And we know partners are natural person. Partners are natural person, but partnership firm is not a natural person. So that means it's neither a legal person nor a natural person. So it fails to satisfy the eligibility criteria of becoming a member in a company. And thereby what happens? This partnership firm with an individual cannot start a company. Followed? Because as we have discussed just now, voluntary association of natural and legal person. Partnership firm is neither natural nor legal. So answer is, it cannot start a company. Clear? Kumari ma'am. Second question. As you could see, Rocky and Rani. Right? Rocky and Rani. Two individuals, two natural persons wants to start a company. Can they? Yes, sir. Definitely. They can. Because both are natural persons. But which company can they start? Private company. Because public company minimum required is 7 members. That we understand. Good. Then, there is a natural person, Munna. And then there is one company. So, one company with one natural person wants to start a company. Can they? Yes. Why? Because company is a legal person and that Munna is a natural person. Natural plus legal. Come on, natural plus legal can start a company. Next one. One company with another company. One company with another company. Can they start a company? Is it possible? Yes. Why? Both are legal persons. So they can start. The eligibility criteria is what? Either it should be natural person or should be legal. Both legal coming together. Both legal coming together and want to start the third legal person. Who's stopping them, boss? And if possible, stop using the word artificial. Better we use the word legal. Euphemisms we said, no? You remember? Right? So words have to be polite. So sir, artificial and legal, polite. Legal is polite. Yes. When you have an alternate word which is polite, then use that. Okay. So we'll use the term legal persons. Okay. Next one. That means last one. If you see here, what is happening? Last one. There is a company and there is Chin Chachu with who wants to start a company. Meaning, sir, there are some foreign citizens. Chi Chachu, do you find name here? Do you find this type of name in India? No. So obviously these are foreign citizens. Who, Chi Chachu, China se, Japan se aaya banda. And they want to associate with some company and start another company. Can they do that? How come? Sir, Chi Chachu, who seems to be natural persons. Seems to be natural person or not? Yes, sir. Definitely. Those are natural persons. So, natural persons with legal person wants to start a company. Can they? Yes, they can. They can. Which type of company they will be able to incorporate? Private or public? Private. Because 3 are there, not 7 again. So like earlier 2, here it is 3. So 3 again doesn't satisfy the criteria for a public company. So thereby we need to understand it's what it's just a private company which can be incorporated. Anyways, I hope you have followed what we are trying to understand here. Natural and legal persons only can start a company, can associate for some common objective. That common objective may be profit motive, may be non-profit motive. Okay, followed the first feature. So like this, every feature when we understand, we need to understand even the application. Okay, sir. 1 minute, sir. Suppose first question comes in examination, sir. First question, which one? A partnership firm wants to join hands with an individual and start a company. Okay, and we said they cannot. If this question comes in examination and we have to write the answer for it, how do we write, sir? How do we write? Okay, let me just rephrase the question. Okay, reframe the question. There's a partnership firm named MSL and Co. MSL and Co. wherein Mehul, Shivek and Lokesh are partners, which want to associate with Balaswamy. Okay, there's a partnership firm which wants to associate with whom? Balaswamy, and start a company, get a company incorporated. Is it possible? Is the question. Now you need to answer. So how will you answer? See, you know the answer, right? I'm just saying, assume this is a question in the examination and you need to answer. How will you do it? Let me understand your viewpoint. Only one. Okay. Yes, Shivani. Get up, madam. Okay. Yes, Shivek. Sit. Very, very good. So first thing why I said very, very good is he started with the provision of company law, because the question is on what? Whether it can be a company or not. So obviously first you have to focus on what? Provision of Companies Act. Now you don't know the exact section and all, that's where he said as per the provisions of Companies Act. Company is a voluntary association of natural and legal persons. Correct? Next, then he came to provision of Partnership Act, because one of the persons which wants to start a company is a partnership firm. So as per the provisions of Indian Partnership Act, a partnership firm is not a legal person. Understood? First we have to write the provision, and we need to know which one we have to write first. Then provision over. Now in the given case, a partnership firm wants to associate with an individual and start a company. So question involved is whether it is possible or not. So we have mentioned, oh, this is the fact and this is the question raised. Now what will we do? We will give our reason. We will give our reason, our explanation. So not answer. No, conclusion will be at the end always. Answer is the conclusion. So don't be in a hurry. Yes, no and all. That will come at the end. Now we'll say, applying the above provisions in the given case, we understand that a partnership firm which is not a legal person is also not a natural person. Whereas the criteria to become a member of a company is to be a natural or a legal person, which is not met in the instant case, in the given case. and hence they cannot start a company. So conclusion will come at the end. Followed. This is how it goes. So when you write like this, where is the chance for the evaluator to deduct marks, to cut marks? You have mentioned properly the provision, you have given your explanation well, you have given the conclusion well, and in between you had time to you mentioned the facts of the given case with question involved. Are you getting it? That is where that slide was there. Which slide? Answer to practical question. I've mentioned, I said we'll take it up later. So when we have scenarios like this, when we have questions like this, when we study something, then I can take up that. Correct? So we'll discuss, then we'll go to that. Anyways, you followed? Followed? So first, what will you write always in the answer to these type of questions? Provision. Second, facts with question involved. Third, explanation. Fourth, conclusion. Sir, in conclusion, if there are some exceptions, there can be exceptions, no? So then what will you do? You will write exception. Like in this case, there is an exception also. Let me tell you that. So if I conclude, yeah, they cannot incorporate a company. Conclusion over. Now I'll say, however, a section 8 company can be incorporated even with a partnership firm as a member. Section 8 company, that is a non-profit company, they say, oh, even a partnership firm can become a member. That's an exception. Section 8, it is mentioned. Section 8 of which law? Companies Act 2013. So that's an exception, and an important exception. You cannot miss it out. Though they did not ask, but we will specify. Clear? So exception will come at the, come on guys, answer at the end. So glossary, you recall, I have given the format of glossary yesterday also. I've shown you. Something was written, general rule with exceptions. So now this is one of the general rule. What is the general rule? Natural person and legal person can be a member in a company. What is the exception? For section 8 company, even partnership firm which is neither a legal nor natural person can also become a member. Exception, no? Come on guys. So that is how you can use glossary. Whenever you come across something like this, and we know we can capture it in glossary so that we can revise it multiple times, we remember it well for lifetime, then you can incorporate there. Okay? Right, sir. So let's move on and talk about the next feature. What's the next feature? Come on. What's the next feature? Registration. So this association of persons which has come together to incorporate a company, simply coming together is not enough. They need to get themselves registered. Registered where? Under what? Under ROC. Under ROC. We'll say with ROC. Don't say under ROC. English सही रहना. अपन क्या बोले? Simple English but grammatically correct. Under वाला meaning अलग हो जाता. Okay, so we cannot say under ROC. We'll say under Companies Act. With ROC. Yes. Now which ROC? There are some 25 odd ROCs, isn't it? You have seen. So my cousin is a ROC in West Bengal. There is ROC Kolkata. Because he is my cousin, I'll go there and get registered. Suppose I want to start a company. Huh? Then which ROC? Particular state meaning? Suppose I want to incorporate in Hyderabad. Then I have to go to ROC Hyderabad. Can't I go to ROC Vijayawada? He is very, very calm. He is very, very professional. I can go there. No, Vijayawada is not that far. So I can go to ROC Vijayawada. Earlier, Telangana was a part of Andhra only. So that connection is also there. No, not possible. Acha, suppose I am going to have factory in Hyderabad. Uncle, no talking like this. Suppose we have a factory in Hyderabad. I want to have a factory in Hyderabad. And I want to have the office where CEO, CFO will sit in Mumbai. Factory in Hyderabad. But CEO, CFO, like that, the officers, the managers, the key managerial person will sit where? In Mumbai office. So I am going to set up an office in Mumbai where these persons will sit. Factory will be in Hyderabad. Where do I get, or which ROC do I go? ROC Mumbai or ROC Hyderabad? How many of you say Hyderabad? How many of you say Mumbai? You're raising hand both the places. And you're not raising any hand. My relative. Just come and said, no, you have to interact as well. I'm not going to punish if you give a wrong answer. Form an opinion. Tell me, ROC Hyderabad or ROC Mumbai? Come on, Kumari madam, form an opinion, I said. Hyderabad. So factory is important. Lokesh, you're raising hand both the places. That's not allowed, man. Only Hyderabad. And answer is Mumbai. Answer is Mumbai. So you need to understand why. As I said, there we are going to have those offices. That means basically we are going to have our registered office there. So when we are going to have our registered office in Mumbai, that means ROC Mumbai jurisdiction matters. Factory might be in Hyderabad, factory might be in Warangal, factory might be in Saudi Arabia. Correct? Anywhere. We are not bothered about factories. We are not bothered about places of business. We are bothered about registered office. And generally registered office is corporate office. Generally. Where these persons sit. Okay. So based on registered office, the jurisdiction is decided. So it's not that any ROC you can go. And don't say for registration purpose, I will go to Nirmala madam's house. Or Mr. Rao Indrajit's house. Deputy of Nirmala Sitaraman madam, if you remember. So we don't go there. Okay. We need to go to ROC's office. But practically you will find people will not say ROC's office. People will say, I am going to ROC. People will say, I am going to ROC. They will not say, I am going to ROC's office. Like people will say, I am going to commissioner. Basically, they should say commissioner's office. Yes, sir, I have heard they say commissioner's office. Okay, good. But have you heard, I am going to ROC's office? At least I have not heard. People say, I am going to ROC. So we understand, okay, they are going to ROC's office. Now, do you think physically we need to visit the ROC's office? Gone are those days. Online it can be done. Submissions can happen online. If they have any question, that can be done online. The certificate of incorporation also can be received by you, okay, online, and then offline also you will get it. But you don't have to go to office. You don't have to go to office of ROC physically. So when we say you have to go, that means we are talking about virtually you need to go. Don't think physically. That is understandable. That is implied now. Okay, sir. Fine, sir. So समझ में आ रहा है कुछ? अच्छा. Suppose now this whatever association of persons wants to incorporate a company, they'll go to ROC and take a selfie. Company incorporated. Selfie, they will frame it on the walls of the registered office. Enough, no? Then what are they supposed to do when they go to ROC's office? They have to fill up some form. They have to prepare some documents, important documents like MOA, AOA, some affidavit, indemnity bond is also required. So all that, whatever documents are required to be prepared or filled, has to be prepared and filled and submitted. Submitted to ROC along with fees. Okay, we have to submit those documents along with what? Fee. Then we can say, yes, we have done our filing properly. And then, since you have paid the fee, you have submitted the documents, ROC should immediately register the company? No. They will go through first those documents. If he has some questions, then what will he do? He'll keep quiet. Because he has questions now, so he should keep quiet. Isn't it? No, he should ask. Right? He should get it clarified. And once he gets the clarification, then once he is satisfied, then he will issue a certificate of incorporation. Certificate of incorporation. COI. बाहर ऐसा मत बोलना, हाँ? Certificate of incorporation, which in short people call it as COI. And before they issue that COI, first the ROC has to make an entry in the register which he maintains. He will maintain a register of companies. In that he will write the name of this company which he is registering, and then give the certificate of incorporation to whom? To whom? Those persons who have applied for registration. Clear? All of you are able to follow? Yes, sir. कुछ तो समझ में आ रहा. Now this thing which we are talking about now, in short, we are going to study in detail. In detail where? Chapter 2. Incorporation and matters incidental thereto. Correct? That is going to be our topic number 2, where we are going to discuss this in detail. As of now, in short, I have written. Okay? Could you see there? Registration. Focus only on second point. Registration. Some association. They're filing documents. With whom? Jurisdictional ROC. Not just ROC. Jurisdictional ROC. There are multiple ROCs. And how will we decide the jurisdiction? As we said, registered office. Based on the registered office. And then, what will ROC do? Acha, and apart from filing documents, what should be there? There should be fee. Payment of fees. Please write also. I cannot give you so much of time that you understand. I read, then you write. है ना वो time चला गया अभी. You have to be fast, quick enough. That's where I said in the first class. Learning involves what? Understanding, writing, interacting. You have to balance that. So filing of documents and then fee has to be paid. And once ROC is satisfied, we'll give the certificate of incorporation after making an entry in the register of companies. Okay, sir. We understood. Now, sir, please ask one question, no, sir, so that we know whether we have understood it well or not. Okay, let me take a very small question, which I have mentioned there as well. What is the date of submission of documents? So, I have mentioned as what? 10th of Feb. This association submitted the documents on which date? 10th of February. And ROC prepared the COI on 15th of February. That means in between he asked questions, he got satisfied and he prepared. Come on, COI on 15th of Feb. Correct? So on the COI, what date was mentioned? 15th of Feb. And then he issued the certificate of incorporation on which date? 17th of Feb. So 10th documents were submitted. The date of COI was 15th. Date of issue of COI was 17th. Now you need to answer, when did the company get incorporated? Is it on 10th? Is it on 15th? Is it on 17th? So please raise your hand if your answer is 10th of Feb. Please raise your hand if your answer is 15th of Feb. Please raise your hand if your answer is 17th of Feb. 17th. What about you, ma'am? No. Behind. 15th. Then you didn't raise your hand. हर दर्द है क्या हाथ में? नहीं तो फिर बोलना, हाथ उठाना पड़ता मैडम. नहीं मैं बोल रहा हूँ सिंपल. मैं 15th का ऑप्शन दिया तब हाथ उठाओ बोला, तो हाथ उठाना पड़ेगा अगर आपका ऑप्शन वो है, आंसर वो है. ठीक है मैम, नेक्स्ट टाइम ध्यान रखिए. सो मेजॉरिटी सेज 15th of Feb and majority is not always wrong. Majority is not always wrong. That means 15th of Feb is the right answer. You're absolutely right. See, date of COI matters. On the COI, on that certificate, what date is mentioned? That date which the company got incorporated. Issue kabhi bhi hoga bhai. Who will remember that? After few years, if someone asks when was it issued, I don't remember exactly. Oh, so look at the date of date on the incorporation certificate. They'll see and they'll find 15th. So they'll say, maybe on the same date they might have issued. Don't you think so? ऐसा ही होता. So date matter करता certificate पे जो है boss. Okay. So date of COI is the date when we will say the company got incorporated. Clear, my dear friends? Registration related point. So in short, I have explained. In detail, we'll see when we go to chapter 2 as I have mentioned. Okay, sir. Right, sir. So first feature we have seen voluntary association of persons. Second feature we have seen, yes, registration. Sir, in registration again, can they ask this type of question in examination? Absolutely. Why not? So again, how will you answer? Suppose they mention, they give some names, okay, A, B, C, D, E, F, G, H, wants to incorporate a public company and thereby they submit the documents to the ROC. Okay, ROC New Delhi, let us say, and the ROC New Delhi receives the documents. On being satisfied, he prepares the certificate of incorporation with 15th of Feb as the date. However, it was issued on 17th of Feb. When was the company incorporated? They frame a question like this and ask you. Then what will you say? So poor response. What will you say? As per the provisions of the Companies Act, a company to come into existence should have a certificate of incorporation received from the ROC. The date on the incorporation certificate matters, or is the date when the company gets incorporated. In the instant case, the documents were submitted on so and so date. COI was having this date, however, issue date was this. Question involved is about the incorporation date. Applying the above provisions in the given case, we understand 15th of Feb is the date when COI was prepared with that date only. So that is the date when we'll assume company is incorporated. Over. Sir, any exceptions here? Every time exceptions will come? No. Why will you talk about exception here? Right? Every time don't think of exceptions and confuse yourself. Chalo. So this is how you need to practice writing answers. It's important because in the examination what? You'll get only MCQs. Like I've asked option number 1, option number 2, कौन बनेगा करोड़पति? No, ऐसा थोड़ी होता है. So we need to understand that the type of questions which will be asked. I've shared with you in the welcome note as well, that you will not just get objective based questions but also subjective type questions. Right? In subjective type you will have practical questions, you will have descriptive type of questions as well. More focus should be on what? Application, practical case studies, meaning they should check your application of knowledge than checking only knowledge, isn't it? We will also like it. Simply they say, write the features of company. Will you enjoy? No, it's not enjoyable or it's not scoring also. But the moment they ask some practical questions, application based questions, you will also enjoy. Correct? Yes, sir. Now let's talk about the third one, sir. And what is the third one? Separate legal entity and corporate personality. So as we said, once the company gets registered, what happens? It gets a corporate personality. It becomes a legal person. What does that imply? It implies that company and members will be considered as separate. As soon as the company gets incorporated, then company and members are separate. How about company and board of directors? So they are also separate. Company and employees, they are also separate. Sir, any person you take, sir, will be different from company. Company has got a separate legal existence of its own, and thereby it can enter into contract in its own name. It can acquire, it can purchase assets in its own name. It can incur liabilities in its own name. It can be sued by others in its own name. It can sue others in its own name. For any violations, penalty will be imposed in the name of the company. So that is how they enjoy a separate existence of its own. Clear? So that's where separate legal entity and corporate personality. So what is A here indicating? Assets. Just now I said no. Assets. L, liabilities. Suits. Right? Suits means what? Filing cases, violations, etc. In what? In the name of company. Company will be punished for the defaults or violations. Clear? Sir, not yet clear. So that's where we take the help of few case laws here, which you might have taken in your foundation as well. So Salmon versus Salmon and Company Limited. So understandable that this is not Indian case law. Salmon versus Salmon. अपने यहाँ क्या रहता? Salman, Suleiman. Isn't it? Salmon थोड़ी रहता अपने यहाँ. So this is definitely a foreign case law. But why are we taking the help of the foreign case law? So that we understand this feature properly. Which feature? Separate legal entity and corporate personality. Okay. So what happened in this case of Salmon versus Salmon and Company Limited? There was this guy, there was this person called as Salmon, who was a proprietor of a shoe business. That means he was running a shoe business, and that too in proprietorship form. How much was the worth of that business? 38,782 pounds. See, from here also you can make it. It's a foreign case law. 38,782 pounds was the worth of the business. When he decided that he should convert his business, which is into sole proprietor, he should convert it into what? Company form. So what did he do? He got the company incorporated. And how many shares were given by the company to Salman? 20,000 shares of how much? £1 each. Then 10,000 debentures of £1 each was also given to Salman. One share each, you can say, was given to his one wife. Okay, and he had only one wife. 4 sons and 1 daughter. That means 6 shares of the company were given to 6 persons. One is his wife, another one again, 1 daughter, and then 4 Nalaikudus, Durmargudus, meaning 4 sons. That way 6 shares were given to them. And how many shares he took? 20,000 shares of £1 each. How many debentures he took? 10,000. Of how much value again? £1 each. So sir, 20,000, 10,000, it becomes 30,000 plus 6, so 30,006. What about the remaining amount? Because the business worth is 38,782 pounds. So that's where the balance was given in cash by that company to Mr. Salman. Followed. Now what happened after some time? Things didn't go well. Things didn't go well. So subsequently, the value of the assets turned out to 6,000 pounds. And the value of liabilities was 17,000 pounds. How much are the liabilities now? 17,000 pounds. Whereas assets are only 6,000 pounds. This happened after a few days, not immediately. Not immediately. After a few days, that is why I have written subsequently. The value of assets turned out to 6,000 pounds and liabilities are worth 17,000 pounds. So liabilities are far more than assets. So decided to close the company, liquidate. So now, if you know, always first the secured creditor needs to be repaid before they pay unsecured creditors, before they pay shareholders. Yes or no? Secured, then unsecured creditors, then maybe shareholders and all. Yes or no? So now, assets are worth 6,000 pounds and liabilities are worth 17,000 pounds. So in this 17,000, we know 10,000 pounds belongs to whom? Salman. Because debentures mean secured creditor. And our debenture holders are secured creditors. So it's for sure that in this 17,000, 10,000 belongs to whom? Salman. So company decided to give that amount of 6,000 to whom? Salman. So Salman is having a loss of how much? 4,000 pounds. 10,000 he has to receive as a debenture holder, but assets are worth only 6,000. So how much will he get? 6,000. So 4,000 will be his loss. Then sir, remaining 7,000. Creditors are, liabilities is worth what? 17,000. So 10,000 is Salman. What about 7,000? Outsiders, unsecured. Correct? So what will they get? Babaji ka thullu, meaning nothing. So they will obviously be getting angry. What nonsense is this? We didn't get even a single penny. So they went to court of law. Correct or not? No, they didn't went to court of law. They didn't go to court of law. But then Salman went to court of law. Case law क्या है? Citation ध्यान दो. Salman versus Salman and Company Limited. So who filed a case in the court of law? Salman, not the creditor. Those unsecured creditors nahi. Salman. He filed because those unsecured creditors were objecting. So he went to court of law. He said, give me protection, my lord. I am the secured creditor. I should be getting this 6,000 pounds which is there in the company. Not those unsecured creditors. But unsecured creditors said that this is one-man company, sir. This is one-man company. Who incorporated this company? Who was the promoter of this company? Salman. Whose business was there earlier? Salman's. Now who is the director? Salman. Who is the major shareholder? Salman. Who is the secured creditor? Salman. Who are the other members of this company? Again, wife, son, daughters, family, that means, of Salman. So that's where the unsecured creditors contended that this is one-man company. And company is a mere sham, that means fraud. Company is just for the namesake, otherwise it is a one person, one man company. Okay, so this is a fraud. So thereby they claim that priority should be given to whom? Unsecured creditors, to us. That is what unsecured creditors started claiming before the court. And what did the court said? Nothing doing. Once the company gets incorporated, Salmon is separate, Salmon and Company Limited is separate. There is a separate legal entity. His idea of incorporating a company was not to do any fraud and all. Okay, his idea was to do business properly, but unfortunately market conditions were not favorable and this condition has arisen. So now, as per the rule, he is the secured creditor, so he will get the money first. And now because enough money is not there, so whatever money is there, 6,000 pounds, no, that will be given to him only. To whom? To Salmon. So with this we are able to understand separate legal entity, corporate personality with the help of this case law. Yes sir. So that's why we took it. Clear? Again explaining the case law once again. First concentrate on the citation. What is written there? Salmon versus Salmon and Company Limited. So we need to understand Salmon is the complainant. Salmon is the plaintiff. He has filed the case. Against whom? The company. Now don't say, "Arey sir, his company only." Arey, separate legal entity. What his company? Now do you think Reliance belongs to Mukesh Ambani only? Mukesh Ambani ka company hai? No. He might be a shareholder, he might be the chairperson, he might be the director. But you cannot say Reliance is his, Reliance is Ambani's. No. Reliance has got a separate existence of its own. Same way, Tata has got a separate existence of its own. Right? Tata Steels Limited. There are several group of companies in Tata Group, isn't it? Like Reliance. So each company is having a separate legal existence. See, there might be sometimes exceptions where company and those members will be treated as one and the same. You know, lifting of corporate will concept. And that will happen in some cases. Those are exceptional cases. But generally, if you talk about company, as soon as it gets registered, is different from its members. Company is different from its directors. Company is different from every other person. See, when I said member, I don't have to say shareholder again. I have told you. When do you become member of the company? When you buy shares. That's the normal rule, isn't it? So when you are a shareholder, that means you are a member. Right. So coming to this case law, Salmon was a sole proprietor having a shoe business which was worth 38,782 pounds. He decided to incorporate a company. He said, let me transfer this sole proprietorship business to company form. Company form always have benefits, no? Yes or no? Do we have or not? How come? Sir, first thing is when you say company, you will be easily getting the trust of people. When you say you are a sole proprietor, when you are a partnership firm, and when you say we are a company, we have some policies in our company, don't you think impression is different? The loyalty will be different, the trust will be different. When you approach a bank and you say we are a company and we want loan, and when you approach saying we are a partnership firm and we want loan, where are the chances of having or getting loan more? Company. So we know that is there because company law is there behind. So if someone is saying we are a company, understand behind is Companies Act, which is so vast and takes care of each and everything. Have got so many rules and regulations, isn't it? So people know that yes, Companies Act will take care of this company, so we need not worry. If I say Balaswamy is coming, a very good family, right? Reputed family, very knowledgeable and educated family. So don't you expect Balaswamy to be like that as well? Yes. Same way, if we say company is regulated by Companies Act, Companies Act, which is so vast and having predefined rules and regulations for each and everything. You want to know provisions of audit? We have chapter 10. You want to know provisions of accounting? We have chapter 9. You want to know about prevention of oppression mismanagement? We have chapter number 16. Like that, you talk about anything, don't you think provisions are there? So there will be a control, there will be regulations on the company, so we can relax, no? If we are the stakeholder, if we are the shareholder, we are the creator of that company, or we are connected in any ways, do you think we need to bother? Do you think we need to have sleepless nights? No. Because we know Companies Act will take care of that company. If company is doing something wrong, company law will strike off the name, will remove that company. We have that confidence. That's why company form of business is a professional form of business. Plus, whenever you want to grow business, whenever you want to expand, don't you think company form is the best one? It's more organized, more professional. Correct or not? So that's where company form of business is what even Mr. Salman thought, with so many advantages. So he thought, let me convert my sole proprietorship business into company form. So he will give this business worth 38,782 pounds to company. Company has to give in return some consideration. So what did they give? 20,000 shares of £1 each. To whom? Salman. 10,000 pounds of 10,000 debentures of £1 each. To whom? Salman. And one share each of £1 each, obviously. To whom? One wife, one daughter, four Durmargrus, four sons, six. And then remaining amount in cash. So now question comes, sir, why did he give one to each? Shagun, Vastu. One share to wife, one share to daughter, four shares to four sons. Why? Because very good. Salman and Company Limited. From the name you can understand. It's what? A public company. And public company requires how many minimum number of members? 7. So with Salman being the member will not help. Only Salman being the member will not help. He needs to have 6 more persons along with him. So that's where he got his family. Okay, but gave them only 1 share each. That means only for the namesake. So otherwise this is what? Under his control totally. Okay. Then what happened subsequently? The company didn't do well, and thereby the liabilities rose to 17,000 pounds, whereas assets had fallen to 6,000 pounds. So when it was this situation, unsecured creditors were not happy and they wanted this money to be given to them. Salman said, no, this money should be given to me because I am the secured creditor. So that's where he filed the case with the code of law. Okay. And now you will say, sir, why didn't he file a case against those unsecured creditors? You might question this. You have to question this. Why didn't he file the case against unsecured creditors? Because he had a fight with them. No, company was anyways ready to give Salman. Then why did he go to court and fought a case or filed a case against company and not against unsecured creditors? Can you tell me? Privity of contract. The contract is between Salman and Company Limited. The contract is between Salman and Company Limited and unsecured creditors. There is no contract between Salman and unsecured creditors. You remember Indian Contract Act or you forgotten? That's how the basics are important. You've read in Indian Contract Act. If A and B are parties in a contract, who can sue A? B. Who can sue B? A. You've read or not? Few exceptional cases might be there. Otherwise, general rule is this only, no boss. So on the basis of that, you need to understand that Salman cannot file a case against unsecured creditors. He has contract with Salman and Company Limited. So he has to file against Salman and Company Limited. That's what he did. But when the hearing takes place, obviously the company will even call, the court, the judge will call even the other party, that is unsecured creditor. They would like to hear from them. So that's where they said, this is a one-man company. Company is mere sham or fraud. That's why priority should be given to us, that is the unsecured creditors, not to this fellow, Salman. But court said nothing doing here. There are no fraudulent intentions. There's nothing wrong which he thought and started a company. Right? So that's where being a secured creditor, he should get priority is what was the judgment given by the court. Followed, guys? Yes, sir. Sir, one more case law, sir, to understand this separate legal entity. Isn't it? Yes, why not? When you are interested, we are here. Lee versus Lee Airframing Private Limited. That's another case law. Explaining what? Separate legal entity and corporate personality. So what happened in this case? In this case, Lee, there was a person called as Lee. Not Brett Lee, Jet Lee and all, okay? Mr. Lee. Bruce Lee bhi nahi hai ye. This is Mr. Lee. Okay, ma'am. You able to follow? No? You able to understand? आंटी आपका नाम नहीं बताया आप. आमिना. समझ में आ रहा है आमिना? बालस्वामी. So Mr. Lee was a qualified pilot. What do you mean by qualified pilot? Not that just with his skills he has learnt driving an aeroplane or helicopter, but then qualification wise also he was what? A pilot. So qualified pilot. And he started a company. He started a company. Which type of company? The company which manufactures aerial top dressing. Manufactures what? Aerial top dressing. What is this, sir? In simple words, if I have to tell you as a layman, rooftop of helicopter. किसका? रूफटॉप? हेलीकॉप्टर का रूफटॉप बनाते थे. उसको हम क्या बोलते? थोड़ा टेक्निकल लैंग्वेज में एरियल टॉप ड्रेसिंग. They used to manufacture aerial top dressing. Who? The company. Lee Airframing Private Limited. Okay. Lee Airframing Private Limited was into the business of manufacturing aerial top dressing. And this person, Mr. Lee, apart from being the promoter of the company, shareholder, director, he was also the chief pilot. He was what? Chief pilot in the company. Okay. Sir, what does the company do? Manufacture rooftops. So do you think after manufacturing that aerial top dressing, they will immediately sell it? No, they will test it. Testing is important, no, here, because it's going to be risky if they just sell it. And for testing purpose, whom do they need? Pilots. So who was the head of the pilots? Mr. Lee. That's why chief pilot. Okay, sir. Now what happened? One day when he was testing one of the rooftops, one of the top dressing, aerial top dressing, he met with an accident and died. And died. That means that was a defective aerial top dressing maybe. That's why he died. Papa. Now his family wanted compensation from the company because during the course of employment, during the course of his work, what happened? He met with an accident and died. So don't you think the family will be asking for compensation? You remember I have told you something about Workmen Compensation Act in India. Same way, there also there will be some law, no? So based on that, they were claiming compensation. Who? Lee's family. From whom? Company. That's why the name of the case law, you just see the citation. What is written there? Lee versus Lee Airframing Private Limited. So who filed the case? Lee. Meaning Lee's family. Lee passed away, Lee died, I know that. So who filed the case? Lee's family. So they were representing Lee, that's why they have mentioned as Lee in the citation. Okay, sir. So now they filed a case and they said Lee should receive, we are the family of Lee, he should receive compensation because while working he died. And what was the company saying? The other officials in the company? Lee and company is one and the same. It was Lee who started this company. It was Lee who was the major shareholder. All that. And what did the court said? Nothing doing. As soon as company gets incorporated, Lee is different. Lee Airframing Private Limited is different. And thereby this company should pay compensation to Lee's family. Followed. So again we could understand separate legal entity concept with the help of this case law. Did we or not? Sure, no? So look at everything, like citation you have to focus. Who has filed case against whom? Right, here it is Lee and Lee Airframing Private Limited. Correct? Yes, sir. Sir, one more, sir. Please, sir. One more, sir. One more. Yes, ye dil mange more, so we have more. Like that, there are number of cases, but this is the last one. Don't worry. Okay, no, sir, we are not worrying. We are rather enjoying. We want more and more case laws. So, what is the next case law we have in front of us? Bacha F. Guzdar versus CIT, Commissioner of Income Tax. CIT means what? Commissioner of Income Tax. So, what happened here? There was a company which was into agricultural business. Which business? Agricultural business. And if you are aware, agricultural income is exempt from tax in India. Agricultural income is exempt from tax in India. You might have read in your income tax by now. Okay, if not, you will be reading it. Agricultural income is exempt. So now what happened? This company which is into agricultural business will earn some income or might have earned some income, and they are not required to pay taxes. Now this income which they have earned, they will give as dividend to their shareholders. Yes or no? They might give dividend, no? So they have given. Okay, in this case it happened. It so happened that they declared dividend and they distributed dividend to their shareholders. Now one of the shareholders said, we are not required to pay any income tax on this dividend income. Reason? This dividend income is coming from that company which is earning this income from agriculture, and agriculture income is exempt from tax. See, I am the shareholder, I am receiving dividend from which company? That company which is into agriculture. So agricultural income is exempt from tax. That means this dividend which I have received also should be exempt from tax. A is equals to B, B is equals to C implies A is equals to C. He applied that mathematic rule, indirect method. And is he right here? Babaji ka thullu. What did the court said? Company is different, shareholder is different. So just because company is exempt from tax, you think you are also exempt from tax? Company is doing agricultural business, you are not doing agricultural business, Babu. You have made an investment in some company and they are giving some dividend, that's it. Are you doing agricultural business? No. Who's doing agricultural business? Company. So thereby for company, exemption will come. Not for you. Followed? So just see there. Shareholder who received dividend claimed exemption from income tax. Court held that dividend received by shareholder is not agricultural income, and hence dividend income is liable to be taxed. Followed? Okay, sir. Sir, you have written held, court held, and then somewhere you have written even upheld. I have written no beside. So I just want to make you understand what is the difference between held and upheld. Court held that, court decided that. Which is better? Court held that. Court gave the judgment, court gave the order. Yes, court held. That's a better terminology. You have to focus on your presentation. Right, sir. So, sir, what's the difference between held and upheld? Now, who filed the case here? Bacha F. Guzdar. And the decision went in favor of CIT. It didn't go in favor of Bacha. It went in favor of CIT. That's where I use the word held. Suppose the decision would have gone in favor of the plaintiff, that is Bacha, then I would have used the word upheld. So whenever the decision comes in favor of that person who has filed the case, that is plaintiff, in this case Bacha, then we use the word upheld. Whereas if the decision comes in favor of the other party, that is the respondent or defendant, then we use the word held. Clear? So tell me, when do you use the word upheld? When the decision is in favor of plaintiff. Don't say Bacha. Every time Bacha will not come. Isn't it? So plaintiff. And when will you use the word held? When the decision is in favor of respondent, that is defendant, that is the other party. In this case, Bacha is the plaintiff, complainant who has filed the case, and CIT is defendant, respondent. They have to respond, they have to defend. Okay, sir. Sir, we understood separate legal entity. We have understood or not? Or you want more cases? Now, please answer my next question. Can we say company is a trust? Can we say company is a trust? You know there is something called as trust. Yes, sir. हमारे मंदिर में trust है, sir. हमारे school का trust है, sir. Like that we use the word trust. No, we know it. Right? You have it. You have an idea about it. I cannot disrespect you. You have quite a good knowledge, isn't it? So can I disrespect you? No, I cannot. I cannot disrespect you and your knowledge, I'm saying. So thereby asked a question with all humbleness. What did I ask? Is company equivalent to trust? सर पता ही नहीं है सर ट्रस्ट आप मजाक उड़ा रहे हमारा ऐसा तो नहीं है ना because you have read about something about trust and CA foundation itself some examples and all you have come across consideration वगैरह आ गया beneficiary very good correct absolutely right so you could recall at least that you have read so that's where I'm asking you chalo let's understand first the concept of trust what happens in case of trust sir there is some author or sponsor there is some author or sponsor you can say author or you can say sponsor who will appoint some board of trustees some trustee give some money to him right author or sponsor will give money no to whom to trustee for some purpose let us say they said construct a temple construct a school to this trustees they constructed now who will take the benefit of this temple school tell me public so who is the public here beneficiaries they're going to get the benefit so they are beneficiaries so there is author or sponsor there is trustees and then comes there comes beneficiaries so even those trustees can go to the temple yes so they are also beneficiaries even the sponsors can go to the temple or school their kids I mean can they go no mobiles in the classes keep it above on the desk see boss next time I'm going to take it I'm going to ask them to take mobile before the class starts this is not acceptable what did I tell you author or sponsor who's giving money and then board of trustees are managing that money whatever has to be done they're doing it and then beneficiary gets the benefit so beneficiary can be even the trustee beneficiary can be even the author yes or no yes sir so sir author or sponsor in trust are they going to manage this temple or school the example which you were taking no trustee will manage sir next thing can any of the sponsor be also trustee yes that's possible let's say 5 persons are author sponsors A B C D E now B wants to be a trustee as well can he be yes if he has that skill he can okay one of the author sponsors can be what trustee okay understood sir so trust concept we understood there is trust deed will have some party who is the party who's the party author sponsor and trustee that's a contract between them no that's called as trust deed like you have sale deed partnership deed same way trust deed who will get the benefits beneficiaries so don't call them as party to the contract the contract is between whom two persons two parties who are those two parties author or sponsors and trustees okay sir fine sir we understood the concept of trust this is regulated by Indian Trust Act if you are aware of it so now is it equivalent to company why did I ask this question first of all see sponsors put in money that means shareholders then board of trustees are like board of directors who are going to manage correct or not and then benefits shareholders might be beneficiaries yes or no whatever the company earn don't you think the benefits will be given to even board of directors they will also take it shareholders also will take it yes or no yes so do you think this is equivalent to trust that's what was my question can we say company is equal to trust see I've shown you the similarities yes sir you have shown the similarities but this is not a trust and thereby Indian Trust Act will not be applicable to company then what will be applicable to company Companies Act Just because similarities are there, does it mean now company will be a trust? No, boss. And you need to understand, whenever we talk about trust, that's a non-profit motive. And companies, profit motive. Now if I start with differences, there will be thousands of differences. Similarities you have seen, and on the basis of similarities, if you conclude trust is company, you will be wrong. Please don't do that. Okay. So that's where I had written here trust and striked it off. You see, written and striked it off. This is called as visible strike through. What is it called as? Visible strike through. Visible strike through, but visible. Yes, sir. We have seen in some pamphlet brochures also, they write fees and then cross it, and still it is visible. That's visible strike through, and then write whatever is the offer fee, offer price. You come across this, no? And there's another way of striking, and what is that? So revenge mode. Like you write trust here. Let's say you write trust here, and then you want to strike it off. Strike it off like this, no? I am not asking you to do that. Okay. What I am asking is visible strike through. So later on you should be able to see that. Clear? So it's not, guys, it's not a trust. What is not a trust? Company. Okay. And this diagram is just trying to help you understand the structure. Please write, ma'am. You're not writing it all. Kumari auntie. Sir, why do you call us auntie, sir? Why do you call us uncle, sir? Huh? Okay. CA Shivani. Yeah, sorry. CA Radhika. Do you mind? Now do you mind? No, sir. Why? Sir, because this is our future, sir. That's what should be our future, sir. CA Shivani. I think you got your answer. Uncle, auntie is also your future. Right? So I don't think I have to elaborate. What, Mehul uncle? ले लो सर, ले लो, खींचो हमारी. Right, sir. So trust will involve trustee or board, will involve sponsor or author. There will be some beneficiaries. The trust deed is between sponsor and trustees. Sponsors are like shareholders, trustees are like board of directors. Beneficiary can be anyone. So is trust a company? The answer is no. The answer is no. Right, sir. ठीक है, समझ गया. Followed or not? So here we complete the third feature in our list: separate legal entity and corporate personality. What is the first one? Voluntary association of persons. Second one, registration. Third one. Now let's go to the fourth one. What is the fourth one? Limited liability. So whose liability are we referring to? Members. Good. Members, not shareholders. We'll say members. So liability of the members is limited. That's our next feature. That's our next feature. Sir, you forgot, I think, that there is something called as unlimited guaranteed companies, sir, where the liability of members is unlimited, sir. Babu, that is an exception. And I have seen you yesterday, the website of corporate data management. How many companies there were there unlimited guaranteed? 308 out of some 14.42 lakh companies. Out of 14.42 lakh companies. Yesterday I have shown you, know, how many were there unlimited guaranteed companies? Some 308. That means for namesake. So generally the liability of members is limited. Exceptionally maybe unlimited. Okay. So liability is limited on what basis? On the basis of shares, on the basis of guarantee. If I am talking about shares, we'll ask a question whether it is fully paid, partly paid. If fully paid, then what's the liability? Remaining liability, zero, nothing. No sir, those shares are partly paid. Then what? If the shares are partly paid, then what? Remaining amount, balance amount. है ना? Remaining amount, that's the balance amount. No sir, it's a company limited by guarantee having shares. Then what? Guaranteed amount plus again share related. If shares are fully paid, then nothing. But shares are partly paid, then balance amount. Company limited by guarantee without share capital, then only guaranteed. So it depends on which type of company we are talking about, right? I think you can just observe. It's very easy and self-explanatory. Earlier also I've talked about it. Ah, sir. Coming to it. Coming to it. Okay, I did not complete anything here. Right? So company limited by shares. What happened? You have just given up, I think. You've raised your hands. Not writing. क्या भाई इतना जल्दी पक गए लिखना limited liability, and that limited liability is of members, not of company we are talking about. So in case the company is company limited by shares and the shares are fully paid, how much is the liability? Zero. No sir, shares are partly paid, then obviously the remaining amount, the balance amount, that's where I've written. Then company limited by guarantee. Company limited by guarantee having shares. Having shares. So that means that's a dual liability, twofold liability. One relating to guarantee, another relating to shares. So as far as shares are concerned, obviously we'll have to again talk about fully paid, partly paid. Fully paid means zero, partly paid means remaining amount, isn't it? देखो यहाँ पर है लिखा हुआ. नहीं sir, that's a company limited by guarantee without shares. Then only guarantee amount. Then only guarantee amount. No sir, unlimited guaranteed company with shares, then what? Then they will have to pay the entire debts and liabilities arising at the time of winding up. And as far as shares are concerned, again the same thing, fully paid, partly paid. If fully paid, then zero. If partly paid, then remaining amount, balance amount. No sir, that's an unlimited guaranteed company without shares. Without shares. So share related liability will not come. Only entire debts and liabilities arising at the time of winding up. That is how it goes. Unlimited. So unlimited means whatever liabilities, debts which are not satisfied, which cannot be paid by the company, will have to be paid by the members. Okay, sir. Sir, when can they call the money relating to shares, sir? Now my question is, when can they call the money relating to shares? If shares are partly paid, when can they call them to pay the remaining amount? Anytime. Anytime. Whenever the company needs the funds, they will call the shareholders and ask them to pay. It is anytime. So during lifetime they can ask, or at the time of winding up also they can ask. That is why I am saying anytime. Able to follow, Mehul? ठीक है, anytime का मतलब क्या है? If I have to spell it out, anytime means during lifetime or winding up. Okay, sir. So share related, we understood. Now what about guarantee amount? Whether the guarantee is limited, whether the guarantee is unlimited. When can they call? When can they enforce? Better word is enforce. Enforce the liability. Only at the time of winding up. Only at the time of winding up. Not during lifetime. Guarantee related liability can't be enforced during lifetime. It can be enforced only at the time of winding up. Winding up. I'm using the word winding up. You're using different words. Sir, but why are you not using the words which we are using, sir? Because there is a difference. You don't know the difference. I know the difference. That's why I am careful. Followed? ठीक है सर. तो एक चीज समझ में आ गया. क्या समझ में आया? एनफोर्समेंट ऑफ लाइबिलिटी. कब करेंगे एनफोर्स लाइबिलिटी? सर डिपेंड्स. शेयर रिलेटेड एनी टाइम. दैट मीन्स लाइफ टाइम और वाइंडिंग अप. गारंटी रिलेटेड Only winding up. Whether limited guarantee, unlimited guarantee, winding. Now the next question comes. Sir, what do you mean by limited guarantee? Amount is fixed. Amount of guarantee is fixed. It's limited. It's fixed. It's specified. Whereas unlimited guarantee, amount is not fixed. That's where unlimited, no? That's why we are saying entire debts and liabilities. Entire debts and liabilities. Correct? So whatever is remaining at the time of winding up, that they need to pay. That amount divided by number of members. So each member how much? That whatever amount comes, that they have to pay. There's no limit. Okay, sir. Followed, sir. So next question, sir. We have, sir, that why will someone become a member of unlimited guaranteed company? Or why will someone become a member of limited guaranteed company? They should become member of company limited by shares, no? Why will one become member of this guaranteed companies, limited or unlimited? What's the reason? Think practically, we are going to be in what? In this profession, bread and butter. तो ये सब मालूम रहना अपने को. कोई बोला क्यों बन रहे भाई, मेंबर क्यों बनना उसका, तो क्या जवाब देते? If someone asks you why people become members of guaranteed companies, what will be your answer? Sir, you want to answer? Answer. Let's see. Raise. खड़े हुए तो सुनाई देता, नहीं तो मेरे को नहीं सुनाई देता. Okay. No. You're very sweet, but the answer is wrong. No problem. At least you attempted. I'm happy with that. You want to attempt, madam? Radhika, ma'am? Amina ji? I'm not able to hear. Sit. No, madam. You're also very sweet, but the answer is wrong. Yes, Mr. Balaswamy, you want to answer? Yeah. Sit, sir. See, guaranteed companies are the non-profit companies. Guaranteed companies are the non-profit companies. That means charity, welfare, all that is the objective, whether limited or unlimited. So now if someone is becoming a member of that charitable organization, that non-profit organization, why is he becoming a member there? To get punya. Punya milna na? Punya, understand? In Hindi we say punya. Punya. Telugulo. English? You want to do good deeds in your life so that you can go to Aishwarya, Urvashi, Rambha, who stays in heaven. And when will you go to heaven, or how can you go to heaven? Only when you do good deeds. चैरिटी करेंगे, लोगों का भला करेंगे, तभी तो स्वर्ग जाएंगे, जन्नत जाएंगे. और जन्नत में कौन मिलेगी? ऐश्वर्या, उर्वशी, रंभा. अब ऐसा मुंह पे तो बोल नहीं सकते ऐश्वर्या, उर्वशी, रंभा. तो क्या बोलते हैं? अच्छे काम करना. ये जीवन में आए हैं तो अच्छे काम करो, पुण्य कमाओ. ऐसे समझ में आया? What is the answer now? Tell me, why will a person become member of guaranteed companies? He want to earn punya. He want to do good deeds in his life. That's where he is becoming member. Now, why do you go to Tirupati? Tell me. Why do you donate there? Why do you go to Chilkur Balaji and donate there? Come on, give me the answer for this, boss. What will you say? Punya, no? Sir, we want to do good deeds. We want to offer to God. Same way this also, boss. Guaranteed companies, non-profit companies, charitable organizations. Why do you want to become a member there and take up the liabilities relating to guarantee? अरे अब मैं इससे ज्यादा नहीं समझा सकता हूं. I think I've explained enough. Right. Next question. Sir, you are using the word winding up, though I said the word liquidation. So is there a difference between the term liquidation, winding up and dissolution? And the answer is yes. All the three terms are different. Winding up is the whole process of closure. तो अंकल आंटी समझ में आ रहे तो लिखते भी जाना कभी कभी बीच बीच में, ठीक है? अभी बोल के नहीं लिखो बोल रहा हूं, but then when I'm sharing something beyond books, you're supposed to write, okay? Now listen to me first, understand, then write. What I'm saying here, there's a difference between three words: winding up, liquidation, dissolution. So winding up is that whole process of closure, whereas liquidation is one of the steps in that process. Liquidation means what? Liquidate, sell off the assets, get money. That's liquidation. So it's one of the steps in the process. That studying is the whole process. Writing is one of the activity there, no? Same way in winding up the process, one of the act is what? Liquidation. And then when winding up is completed, the whole process is completed, what will happen to the company? It will get dissolved. That means close. So if someone asks you what is winding up, you will say closure process. Process of closure. What is dissolution? Closure. Closed. And what is liquidation? One of the steps in the process. Followed? All of you understood? So chapter 20, which you have in Companies Act, is having the heading of liquidation, dissolution, no, winding up, because the whole process, in that process liquidation will come, of course. In that process, once the process is over, dissolution will come, yes. Clear? When you study, that process gets complete. Will you pass? Is there a chance of passing? Yes, sir. Yes, sir. Results are out, we passed. Same way, winding up over, dissolution happens. Closure happens. अरे ऐसा बिहेव मत करो, कुछ समझ में नहीं आया वैसे बॉस. Did you follow or not? Did I explain something very difficult? No. So which is the right term to use? Winding up. That is the process of closure. So during winding up, I cannot say at winding up. This is the process. So during winding up, guarantee amount can be enforced. But share related liability can be enforced anytime. Anytime meaning lifetime or winding up. Don't simply stop at any time and relax. Anytime. You have to spell it out further. And say what? It means lifetime or winding up. Okay? Yes, sir. Now, you need to answer, not disturb others. Okay? You need to answer. There is a private limited company which wants to become a partner in partnership firm. Private limited company is there which wants to become a partner in a partnership firm. Is it possible or not? And I'm asking you this question because the liability of partners is unlimited. The liability of partners is unlimited, no joint and several, unlimited. Did you read this or not? So that's why I'm asking this question. My question is very simple, ma'am. What's my question? A private limited company wants to become a partner in a partnership firm. Can they become? You have to answer yes or no. With reason, of course. So let's see who can answer. Very simple question. Yes, Madam Shivani. I thought of clapping, but then somewhere last May you have done that mess. Anyways, good. At least you have some clarity. I appreciate you for that. Very good. See, a company is a legal person, separate legal entity. It can contract in its own name. We have read this. So obviously it can become a partner in a partnership firm, because in order to become a partner in a partnership firm, you should be a natural person or a legal person. So thereby it's quite possible. Then next question, sir, liability of a partner will be unlimited. Yes. So this is a private limited company. As a partner, their liability will be what? Unlimited. Their liability will be what? Unlimited. So what's wrong in it? No, sir, you are talking about a private limited company, sir. Array, in private limited company, the liability of members will be limited. No? Private limited company means liability of members is limited. See, here also I've written limited liability when we're discussing. It's of whom? Members. We're not talking about company. Company can take up unlimited liabilities. Followed. So, as far as private limited company is concerned, they can become a partner in partnership firm and get unlimited liability? Yes, very much. They can enter into some contract and can get unlimited liability? Yes, very much. In private limited company, what is limited? Liability of members is limited. Don't get confused with this, huh? Same way if I say there is a public limited company, it wants to enter into a contract and get unlimited liability. Can they? Yes. Public limited company. So liability of members is limited there. But the company can take up unlimited liability also. Who's stopping them? Clear, Kumari madam? Private limited company, what is limited? Liability of members is limited. Public limited company, what is limited? Liability of members is limited. Whereas liability of company can be unlimited also. Did we study anywhere till now? Did I say anywhere that the company has to take up limited liability only? Tell me now. Did I tell you anywhere? No. Isn't it? We said liability of members is limited, boss. हम कभी नहीं बोले कंपनी का लाइबिलिटी लिमिटेड रहता बोल के. कंपनी का मर्जी, जो लेना है ले लो, जो कॉन्ट्रैक्ट करना है करो, जिसमें अनलिमिटेड लाइबिलिटी आता है आने दो. No one, nowhere there is a prohibition. Clear? Remember, huh? Okay, sir. Sir, ये understood. But ये, see, in this heading, why did you write limited liability of members, sir? Huh? Sir, because when you are discussing this concept, you are discussing unlimited liability also. Huh? Did you follow what I am asking you? I have put the heading as limited liability. Whereas when we are discussing this concept, we discuss company limited by shares. That means limited liability. Company limited by guarantee, so limited liability. Also we have discussed unlimited guaranteed company, that means unlimited liability. So why is the heading only limited liability? Why I am not putting the heading as limited and unlimited liability? Good. We said no. In the beginning itself, that's an exception. Unlimited guaranteed company is hardly there. So why should we put it in the heading? So in the heading, what did we put? Generally, what is there? Out of 14.82 lakh companies, if you subtract 308 companies, all other companies are limited guaranteed companies, no, or limited, no, not limited guaranteed, sorry, limited companies, no. आ रहा समझ में? So unlimited is just an exception name, just few. If you take out percentage, you'll understand. It is not even 0.1%, lesser than that. इसलिए उसको नहीं लिख रहे साइड, I mean heading में. ठीक है? Followed? Okay, sir. So this completes our fourth one. Let's move on to the fifth one. What's the fifth one? Balaswami Garu. Concentrate here. Share capital. Next feature. So the capital of the company is divided into shares. Good. Divided into equal parts, small parts. Each part is uniform and is called as share. Don't say share. Share nahi hota. Share tiger hota. People say no, share market. It's not share market. It is share market. Share. So share capital. It's not share capital. Anyways. So the capital of the company is divided into what? Small parts. See, this is the capital. Now they have divided into small parts. Don't go by my drawing skills, huh? Drawing skills are poor, as you could see. But you could understand the feelings, the intention. That's more important. So capital of the company is divided into small parts. Each part is called as what? Share. So if I ask you, what is this? You'll say share. What is this? Share. What is this? Share. Each part is share. and we'll have a face value, nominal value. We'll have a value, no? And that value is called as what? Face value or nominal value. Sir, but why did they divide the whole capital into small parts? What is the reason? To make it affordable. If it becomes affordable, more and more people will subscribe to the shares. That means company will be able to mobilize huge amount of funds. If company wants 3 lakh crores. Huh? Sir, how much? 3 lakh crores. Now imagine 3 lakh crores can one person give? Even if he has, he will not give. Who will take that much of risk? So you need to raise that 3 lakh crores by way of shares, small shares. Now you want to buy 2, you buy 2. You want to buy 20, you buy 20. You want to buy 30, you buy 30. You want to buy 56, you buy 56. You want to buy 10,000, you buy 10,000. Adam, how many you want to buy? Okay, 20,000. 20,000 you buy. Radhika? 70. Okay, 70 you buy. Like that. Whatever number you want to buy, you can buy. It becomes affordable, no? Now you are interested in buying one share of Reliance Industries Limited. Buy. So with one share, with some not even 1,000 rupees, you will become what? Shareholder of Reliance. That's possible because of this concept. Isn't it? It's possible because of this concept. The whole capital is divided into small parts and each part is share. So buy share and become the owner. Of course, you will not be the whole owner, you will be the part owner, but you will be the owner. So company can mobilize huge amount of funds. Drops and drops makes ocean, as we say, no? That's what is happening here, no? You buy 2 shares, 3 shares, as I said. So then company will get huge amount of funds. With huge amount of funds, do you think they can do those type of businesses wherein more investment is required? Yes, sir. More investment is required, then which form is better? Company form. In company form also, which one? Public company, not private company or OPC. More and more money required. Which company you will register? Private. Public. Isn't it? You will go for listing or not? Yes, we will get it listed as well. Okay, sir. So we understood. Now, these types of shares are divided into 2. What are those 2? Equity shares, preference shares. Right? In equity shares, generally there is only one class. However, exceptionally, there are even equity shares with differential voting rights. उधर देखने का, ठीक है? In equity shares, generally there is only one class, one type. However, exceptionally I am saying there can be equity shares with differential voting rights. DVR we say. Equity shares with DVR, meaning equity shares with differential voting rights. Acha sir. So there will be some differentiation in voting rights. Yes, but those are exceptional cases. And we will discuss in detail about this. In which chapter? Share capital and debentures, chapter number 4. There we'll talk about it. Sir, which company can issue this equity shares with DVR? What eligibility criteria is required to be met? What conditions, what procedure needs to be followed? All of that we will discuss, don't worry. When will we discuss about it? Chapter number 4. That's going to be our topic number 4 as well. In topic 4, we have chapter 4 plus some other provision. Right now we are in topic 1. And topic 1 covers chapter 1 plus some other provisions. Not just chapter 1. Correct or not? I've given you the overview of this topic 1. Okay, sir. Okay. Another type is preference. Acha. Now please answer my question. Let's see. Can a company have only preference shares? Someone is saying no. You agree with him? Can a company have only preference shares? Just imagine there is only one student in the class, Mehul. There is only one student, let's say. And I say, I will give preference to you. I give preference to you. Then what will he do? Laugh. Laugh. He'll say, sir, what nonsense. I am the only one. So obviously you will give preference to me only. No, sir. Rather, there is no need to say preference. I am the only one. Simple. Same way. There are no equity shares. There are only preference shares. And we are saying we'll give preference to you. We'll give preference to you. They'll laugh. Array, if there are two types and then you say that we are going to give preference, it makes sense or not? Now 50 plus students are here and I say, Mehul, I'm going to give you preference. Is it making sense or still he will laugh? No, it will make sense. Because out of 50 plus, I'm saying I will give preference to you. That's going to make sense. English word preference भाई तो कोई दूसरा तो रहना ना, तब तो preference का बारी आता. तो can a company have only preference shares? No sir. Equity preference both, then the preference has meaning. Acha, can they have only equity shares? Yes, that's possible. That is possible. Right, sir. In preference shares, we have different types like cumulative, convertible, then redeemable, participating, non-participating, non-cumulative, non-convertible. Like that, we have different types. That we'll discuss later when we go to the topic share capital and debentures. Fine. बाद में करेंगे डिस्कस. अभी क्या करते हैं? कुछ जरूरत भी नहीं है उसका. If there would have been a need, I would have discussed it. So just return it, but we'll discuss it later. Okay, sir. Share capital is what we have understood now. The feature. Now let's go to the next one. What's the next feature? These shares are transferable. You forgot so early. I've given you the clue also. Sequence. Voluntary association of persons needs to get registered. And once they register, it becomes separate legal entity and a corporate personality. So that means liability of members will be limited, and that will be mainly on the basis of shares, share capital. Those shares are transferable from one person to another. That means there will be perpetual succession, and there is also a reason of perpetual succession, that is separation between ownership and management. We have some clue logic, and that's where we can remember the whole list of features. Okay, so now let's talk about what? Transferability of shares. Transferability of shares. If you're not able to understand anything, or if you have any doubt, if you have any question, please raise your hand. If you don't raise your hand, I presume you're able to follow, and then I proceed. Transferability of shares, meaning the shares which a person buys, he can transfer to another person. Even in case of private company, it can be done. However, there's a restriction in private company, unlike public company. In public company, shares are freely transferable. That means no restriction. Freely doesn't mean free of cost. Freely means no restrictions. Whereas in private company, there are restrictions. So restrictive transfer is possible, but it is possible. Okay. Shares are transferable from one person to another. In case of private company, with restrictions. In public company, no restrictions. In public company, there are no restrictions. But private company, there are restrictions. Okay, sir. Sir, what is that restriction which is put in case of private company? Preemptive clause. What is preemptive clause? You've read in CA Foundation these fundamentals. Answer. What is preemptive clause? Sir, before actually starting CA inter classes, I was so happy that I cleared my CA Foundation. Now you're ruining that happiness. You're insulting us like anything. CA Foundation, you've read this, CA Foundation, this, that and all. So now it's haunting. This has become a haunted feeling, clearing CA Foundation. I hope that's not the case. Sir, no comments, sir. No one? Okay, so what is preemptive? It means first offer to the existing ones. If the existing ones do not want to purchase, then you go to outsiders. And that outsider should be acceptable to the existing one. What, sir? What are you saying? Let us say there are 4 members in a private company. Balaswamy, Lokesh, Amina and Shivani. Now Amina wants to exit this company. She is a member along with the other 3 members. Okay, she wants to exit. So she wants to transfer the shares, transfer her shares. So she says, I will transfer to Kumari madam. Can she do that? No. First, she'll have to offer to whom? The existing one. That means Lokesh, Balaswamy, Shivani, those 3 other members. Suppose they are not ready to buy, they are not willing to buy. Then she may offer to Kumari madam. And Kumari madam should be that person who's acceptable to these 3. They say, yeah, okay, no problem. Then you can. That is preemptive clause. No, sir, Kumari madam is not acceptable to them. Find another person then. Okay, Shivek, will you buy? Shivek said yes. She has to ask other 3. Is Shivek okay? Okay, come. No, not okay. Then another person. Like that it goes. Preemptive clause. Preemptive. That means you have to give chance to first the existing persons. If they don't, then some outsider. Private company, no. Private group, closed group. So you can't get anyone whom you want. Right, sir. We understand. So did you follow this first? This part? What do you mean by free transferability? Free of cost. Without restriction. That means in a public company. Suppose Amina is a member of public company and she wants to transfer her shares to Kumari madam. Do you think she has to ask Balaswamy? She has to ask other members of the public company? No. There are no restrictions. You can transfer to any person whom you want. That's public company. Okay, sir. Sir, what is the procedure for transfer of shares? And the answer is, it will be specified in Articles of Association. Memorandum of Association is a document which will answer the question what, and articles will answer the question how. What? MOA. How? AOA. So this is how only. Can we transfer the shares? The answer is in AOA. That will specify the procedure for transfer. Now, just because we said it can be transferred from one person to another, does it mean shares becomes negotiable instrument? The answer is no. The sleeping S is what? Is the sign for negation, mathematics. पढ़े ना मैथमेटिक्स में नेगेशन साइन स्लीपिंग एस. क्या सर वो भी यूज करते हैं आप? हाँ, क्यों नहीं? So it's not a negotiable instrument. Reason, as per Negotiable Instrument Act 1881, only 3 instruments are considered to be negotiable instrument. Which are those 3? Promissory note, bills of exchange and check. So only these 3 are considered to be negotiable, not shares or not anything which you want to. Right, sir. Now Amina, who has purchased shares of a company, is in need of money. So can she sell her shares? Yes, sir. Later on, she earns some money from somewhere. So she has some surplus, some savings. So she wants to buy. Can she buy? Yes. That means whenever she wants, she can sell. Whenever she wants, she can buy. That means, don't you think this is providing liquidity? This is encouraging investment? Yes. This is encouraging investment. No. Now you will be encouraged. Oh, whenever I want, I can invest. Whenever I want, I can take out my money. Good. This will give you flexibility. So thereby the company will get investments. You will have liquidity. So thereby you will be motivated enough to invest. So company is getting the benefit of it. Isn't it? Yes, sir. Then whenever we are talking about investor selling to another investor, it is happening in secondary market. Then what is primary market? Company issuing shares to investor. That's primary market. But when investor plays, that is secondary market. You bought it on stock exchange. So what is stock exchange? Secondary market. Correct? Lokesh bought it from Shivek on stock exchange. Secondary market. Mehul bought it from Kumari madam. Secondary market. Kumari madam got it from company directly. That's primary market. So when company was issuing, Kumari madam has applied at that time. And they issued to her, they allotted to her. So that becomes what? Primary market. So company to investor, primary market. Investor to investor, secondary market. Very good. So whenever we talk about transferability of shares, are we going to say primary market? No, it's secondary market. Okay, sir. So manner of transfer is provided in articles. In private company, there are restrictions, that is preemptive clause, but public company is freely transferable. Just because it is transferable doesn't mean that it is a negotiable instrument. The idea behind putting this transferability clause is to encourage investment, isn't it? To give that liquidity in the hands of the investors. And all this transferability happens or takes place in secondary market. Some points or few points we have understood. Where are we going to discuss in detail about this transferability of shares, my dear friends? Chapter 4, share capital and debentures. There we are going to talk about it. Okay? Yes, so. Acha, by the way, where are we getting all these features from? We are discussing different features. Where are we getting it from? Sir, Act. The Companies Act. Acha, in Companies Act, where are we getting it from? Only chapter 4. No. Registration related chapter 2, no. Separate legal entity, corporate personality, chapter 2, no. So we understand it is from different chapters, different provisions. We are trying to understand the different features of company from different chapters, different provisions and bringing it here. Are you able to follow? So if someone asks you to write the section numbers, chapter numbers, can you? Yes sir, we can. But as of now, because it's beginning, we are not bothering about that. But when we go to the respective topics and study these things in detail, that time we will bother about the section numbers or not, the chapter numbers or not. Yes sir, we will. Okay. Chalo. Next one, you please tell me. Perpetual succession. What do you mean by perpetual succession? Continuity. It goes on, goes on, goes on forever. So members may come, members may go, but the company goes on forever. That means company is in existence because of law and company will come to an end because of law. Company comes into existence because of law, company will come to an end because of law. If a member dies, will it affect the existence of company? No. If a member becomes insolvent, will the company's existence come to an end? No. If there is a change in the name of the company, will it affect the existence of the company? No. If a private company becomes a public company, gets converted into a public company, is it going to affect the existence of the company? No. Right? Instead of Amina, now Munni has become the member. Instead of Balaswamy, Radhika has become the member. Will it affect the existence of the company? No. If Adam dies, Adam is a member of the company, he dies, will it affect the existence of the company? No. So please understand, company being a legal person, members may come, members may go, but the company goes on forever, forever, forever. Come on, repeat. Did I say only repeat forever? Dirty fellow. What will you say? Company being a legal person, members may come, members may go, but the company goes on forever, forever, forever. Come on, Kumari madam, enjoy. Enjoy the subject. So please, company being a legal person, members may come, members may go, but the company goes on forever, forever, forever. Understood? That's perpetual succession. So death or insolvency of member is not going to impact the existence of company. Death or insolvency or insanity of member is not going to impact the existence of company, because company is created by law and company is going to come to an end by law. Sir, defunct, that is also by law only, no? ROC cannot declare any company as defunct. It has to follow the procedure. Chapter number 18. Chapter 18 has got those provisions relating to defunct companies. So they have to follow that. Change in name or conversion of companies. Will it affect the legal status of company? No, no, no. Correct? It's not going to change the legal status of the company. Fine, guys. So that's what I can say when it comes to perpetual succession. It comes into existence because of law. It is run or managed as per law. It comes to an end also as per law. तो सब कुछ लॉ के हिसाब से होगा. पैदा, जीवन, मरण, सब लॉ के हिसाब से. Okay, sir. So now let's discuss the last feature in our list. Last meaning not last as such. I said in our list. That means there are more features. I've told you different features we can pick it. But in our list we have covered a few important ones. So next one is separation between ownership and management. Ownership and control. Correct? Acha. Can I say divorce between ownership and management? Yes, sir. If you want, you can. Because divorce also means separation. That's where few books you will find they'll use the word divorce between ownership and management. But because I'm married, so that's where I have not used the word divorce. I've used the word separation. Don't write such thing in exams, huh? Otherwise you'll just no, our sir also used in the class, so we'll write. I mean, divorce word you can use, but I'm saying these reasons or these things which we just crack for the sake of having some fun. So those things need not be written in the exam. So separation between ownership and management. What do you mean by this? Sir, the board of directors are the one who are going to manage the company, isn't it? They are elected board of directors who are going to manage the company. The management of the company lies in the hands of the board of directors. Whereas the ownership belongs to whom? Shareholders, who cannot interfere in the day-to-day management of the company. Now, I said some time back, you bought some share of Reliance Industries Limited. And let's say tomorrow you go to Mumbai and you go to that Reliance office, okay, registered office. Do you think security guard will stop you there itself? And you'll say, I am a shareholder of this company, I am an owner of this company, allow me. And he'll say, हाँ sir, you go. Is it like that? Or he'll put garland, huh? फूलों से स्वागत करता, बहारो फूल बरसाओ, मेरा shareholder आया है. Is it going to be like this? No. So please understand. You'll say, no, I want to see that ledger. I want to see that creditors account. I want to see the quality of raw material which you are using. You think they will allow? No. You cannot interfere in the day-to-day management. Whenever there is a general meeting and you are being called, that time you visit. Or if you want to inspect something, there is a procedure. Not like you wake up and you go there. Suppose you want to inspect some register, you want to inspect some particular index, some particular contract, which is allowed as per law. There are some rights available to the member to inspect. So you have to use them properly, not like whenever and however you want to use it. They will not allow. No, I think the price of this product should be lesser, boss. Change it. You as a shareholder are saying this and they listen to you. No. Non-routine matters, you will be involved in decision making. Routine matters, day-to-day matters, who will take care? Management. But obviously, they should have restrictions on their powers. Their powers should not be unrestricted. No? Should be restricted. Restriction should be there. Mama says, go for a movie, no problem, beta. But come back before 9 o'clock. That means that's a restriction. They gave the power. They gave the power to you to go to a movie, but then said, come back before 9 p.m. So that's the restriction they've kept. Required or not? It is. You have chapter number 12. Directors, meetings, powers, restrictions. You remember? Acha. I have written the word elected board of directors, not selected. Selected and elected are different. Do you think this academy has elected me? No, this was selection. Suppose I say no, they, go for an election and they give you a choice to cast your vote, then they will have a faculty appointed, teacher appointed. Then what will it be? Elected teacher. But that's not the case. However, in directors, in the board, obviously election has to take place. Okay, election will take place. Who will have the right to vote? Shareholder, member. Shareholder, that is the member who will have the right to cast his vote. and then decide upon who can be the director of this company. Clear? Clear? All of you followed? ठीक है सर, समझ में आया. तो elected word है वो, selected नहीं, याद रखना. How is the prime minister of this country appointed? Election. So elected PM, elected CM, correct? So we know elected word should be used when there is an election and there's a democratic process of selecting the person, not simply pick and appoint. It's not like that. Okay? ठीक है sir. So we followed this much. Acha, what is the other name which we gave to this? Oligarchic management. You remember? Separation. So indirect control is there of the shareholders or members indirectly, but not directly. Day-to-day basis, no, it's not possible. So now we have understood all the features. Can we come up with the definition now? Acha sir, we were discussing definition. Yes, yesterday we started with what? Definition, but we were not getting a comprehensive definition. So that's where we said, first let us discuss few features, and after that we will frame our own definition of company. ठीक है ना? बोलो. So now we know all the features. These all the features in the sense all the important ones. Can we frame a sentence where we can cover all this and say this is the definition of company? Yes sir, we can. Let's try. Company is a voluntary association of persons registered under the Companies Act. I'll not say which act. I'll say Companies Act. I'll not say 2013, 1956, because if I say under Companies Act, it can be any. Having separate legal entity and corporate personality of its own, with limited liability of the members, and having characteristics like share capital, transferability of shares, perpetual succession, separation between ownership and management. If I give this definition, don't you think it looks comprehensive? Come again. What did I say? Company is a voluntary association of persons having registered under the Companies Act with or getting a separate legal entity and corporate personality of its own, with members' liability being limited on the basis of share capital, with features like transferability of shares, perpetual succession, separation between ownership and management. Sir, you're going too fast, sir. Because already it is mentioned. Oh, this is getting upset. Oh, further upset. What happened, Babu? It's not ready to move only. What, Mehul? You're not praying, boss. Oh. Now it will, isn't it? Sir, how do we know, sir? Arey, you know everything, boss. See here. Come on, read. See here means what? Only see. Company is a voluntary association of persons registered under the Companies Act 2013 or under any other previous acts in force with a separate legal entity quite distinct from that of the members who constitute it. A corporate personality with the characteristic features of limited liability, perpetual succession, share capital, transferable shares, and divorce between ownership and management. So how did we arrive at this definition? On the basis of features. Did we discuss till here? Just see. Voluntary association of persons. Did we discuss? Yes, sir. Registration? Yes, sir. Separation between ownership and management with case laws like Salmon versus Salmon and Company Limited, Lee versus Lee airframing. Rather, I have covered one more. Bacha, CIT. You remember? Then limited liability of members we talked about. Perpetual succession, share capital, transferability of shares, separation between ownership and management. Till here we have covered. So when we meet in our next session, we are going to begin with limitations of company. ठीक है ना? Next session when we meet, we'll begin with what? Limitations of company. So daily basis, keep checking from the book as well. If I am not referring the printed material which has been given, you should be doing it. So what is covered? Put a tick mark. Yes, this is covered. So from page 1 or whatever number of page, okay, to page number 4, it's all done. Page number 5, limitations, is what we will continue with. Okay, now any doubts till now? Not just today's class, any of the previous sessions also. If you have any doubt, please ask before I close the session. No, no doubts? Sure. Okay. Anyways, if you are not getting doubt now, but when you read at home, when you revise at home, you get it, then ask me tomorrow, ask me in the next session. Huh. Good question. He is saying, suppose the decision goes in favor of plaintiff. Then we use the word upheld. Instead of upheld, can we use held? The answer is yes. Okay, no problem. That means held word can be used in either case. But upheld has to be used only in case of decision going in favor of plaintiff. Very good. Followed, upheld word only when decision goes in favor of plaintiff. Whereas held word, decision in favor of plaintiff or even respondent. No problem. Held word chalta. Upheld nahi chalta. So careful रहना upheld words. Any other doubt? No? Sure? Thank you. God bless you all. See you all in the next session.